and welcome everyone to the Polity Primer series of Drishti IAS. My name is Pragya and today we are going to discuss Mercy Petitions and what will change in the law on Mercy Petitions if the Bhartiya Nyay Suraksha Sanhita comes into effect. In this discussion, we are going to study about what is the law on Mercy Petitions and the constitutional provisions regarding it. We are also going to study the new provisions of Bhartiya Nyay Suraksha Sanhita or the BNSS. We are also going to see the contravention of legal precedents if these new provisions of Bhartiya Nyay Suraksha Sanhita comes into effect. That means how they will contradict the existing legal precedent. Then we are also going to see some of the past cases of multiplicity of mercy petitions, and in the end we are going to see a practice question for your prelims examination and a practice question for your mains examination. Now let us proceed to understand the background of our today's topic. So you might be aware that the Parliament has brought 3 new bills to replace the IPC or the Indian Penal Code, the CRPC or the Code of Criminal Procedure and the Indian Evidence Act. So the proposed Bhartiya Nyay Suraksha Sanhita is set to replace the CRPC if it comes into effect, and this has proposed a huge change in the foundation of the law on mercy petitions. It has changes regarding justiciability. It also has changes regarding time limit and time gap between the dismissal of mercy petition and its execution. So we are going to study all of these in our further slides. Now let us understand the law on mercy petition and the meaning of this term mercy petition. So if we talk about the meaning of this term mercy petition is a plea by a convict who is facing the death sentence or life imprisonment. Death sentence or life imprisonment, and he is pleading mercy from the President of India and or the Governor of the state in the case of a state law. So both President of India and the Governor of the state have power to grant mercy. It is one of the last resorts available to the convict if he has exhausted all of his legal remedies, and this remedy is available on humanitarian and compassionate grounds, because there is an ongoing debate in India regarding abolishment of death sentence, as it is considered to be very cruel in nature to the convicts. So there is an ongoing debate that death sentence in India should be abolished. So we try to protect the right to life of every person who is an Indian citizen. So this right to live is also available to a person who is sentenced to death sentence or life imprisonment. So if he has exhausted all of his legal remedies, he can then approach the President of India or the Governor of state, and then by way of a plea known as the mercy petition, he can plead mercy. So if we talk about the provisions of our Indian Constitution in this regard, Article 72 of our Indian Constitution gives the power to the President of India. And Article 161 of our Indian Constitution gives the power to the Governor of the state. This power under Article 72 and 161 of the Constitution of India includes 4 things. That is, they have the power to pardon. Pardoning means completely absolving the convict of the sentence and any punishment. That means he can live free. All of the punishment and the sentence or the conviction has been set aside. This is known as the power of pardon. Then there is a power to reprieve. Reprieve means to stay the sentence. For example, the convict has been awarded a death sentence or a life imprisonment, then reprieving it means staying the sentence for execution so that he can have the time to approach the President of India or for that matter the Governor of the state to plead mercy. Then there is a power known as respite. As the word itself suggests, respite means that you have been awarded a lesser sentence. For example, you have been awarded a rigorous imprisonment of 20 years. Then it can be reduced to 10 years. Then there is a provision for remit. What does remission means? Remission means reducing the sentence. So respite means you have been awarded a lesser sentence, and remit also is of the same characteristics, that your sentence has been reduced. So the Article 72 and 161 of our Indian Constitution gives these 4 powers to the President and the Governor of the state. So how do Article 72 and 161 differ from each other? So if we talk about the cases of death sentence, only President of India has the power to pardon the death sentence. This power is not available to the Governor of the state. So even if the death sentence is awarded under the state law, the mercy petition will go to the President of India, not to the Governor of the state. And then President of India also has the power to pardon the sentence given by court-martial proceedings. So this power is also not available to the Governor. However, in case of a death sentence, the power of the President and the Governor of India are coterminous with each other if we consider the suspension, remission and the commutation of sentence. For example, the President can also suspend the death sentence, so as the Governor. He can also commute the sentence to life imprisonment, so as the Governor, and he can also give stay on the death sentence, so as the convict could approach the President of India. So in these aspects, the power is coterminous with each other, concurrent with each other, but the Governor is not empowered to pardon the death sentence. This power is exclusively available to the President of India. However, our Indian President has no discretionary powers under our Indian Constitution. So he is dependent on the aid and advice of the Council of Ministers, and this was held in the case of Maru Ram versus Union of India. Maru Ram versus Union of India. In this case, the Supreme Court has specifically held that the President, in the case of mercy petitions as well, is bound by the aid and advice of the Council of Ministers. He can only send it back under Article 74 Clause 1 for reconsideration. But if the changes suggested by the President, then he will have to proceed with their decision. He cannot have any discretion in this regard. He is completely bound by the aid and advice of the Council of Ministers. Now let us see what are the new provisions that have been introduced under the Bhartiya Nyay Suraksha Sanhita. So as I was explaining this before, that the President in the case of mercy petitions as well is bound by the aid and advice of the Council of Ministers. But this is not the case in the case if the provisions of Bhartiya Nyay Suraksha Sanhita come into effect. What will happen is no requirement for the President to act on the advice of the Council of Ministers. In case of a death sentence, kindly remember this term, only in the case of death sentence. So what does this mean? It means that the President can act on his discretion. So this foundation of the President to be bound by the aid and advice of Council of Ministers has changed in the proposed new provisions of the BNSS. So Section 473 Clause 1 allows a convict under the sentence of death. So the person can be convict, his legal heirs or his relatives. So they can ask the mercy from President of India and Governor of the state within 30 days, and this 30 days will be counted from the time when they have received the information about the dismissal of their appeal in the Supreme Court or dismissal of the special leave petition in the Supreme Court. Then if they have been informed about the date of the confirmation of the sentence. So the time period of 30 days will start running from once they have received the information that their dismissal appeal is dismissed against the sentence or the SLP is also dismissed, and once they know about the date of the death sentence, that is the execution of the death sentence. So they, under the new provision, they can directly approach the President of India or Governor of the state. Then section 437 clause 7 talks about no provision for appeal or judicial review. This is very important. No provision for appeal or judicial review of President's decision. That means the power of judicial review of the Supreme Court is curtailed. Previously, what happened was, if the Supreme Court found out that the decision of the President for dismissing the mercy petition is arbitrary, is on malified grounds, then it could intervene by using the device of judicial review. But this power of judicial review has been curtailed under the newly introduced provision of BNSS. So these are the new provisions which are proposed to be introduced under the Bhartiya Nyay Suraksha Sanhita. Now let us understand a contravention of legal precedents by these provisions. So I was explaining this before also, that these newly proposed provisions are in contravention of the important decisions of the Supreme Court. So in October 2006, in Ipuru Sudhakar and other versus Andhra Pradesh and other, the SC held that the powers of President of Governor under Articles 72 and 161 are subject to judicial review. So this was what I was talking about previously and explaining to you previously, that under section 437 clause 7 of the newly proposed BNSS, the power to appeal or judicial review has been curtailed, and this provision is in directly conflict with this decision of the Supreme Court, in which it has held that the awarding of mercy petitions or the dismissal of mercy petitions by the President or the Governor of State are subject to judicial review. And what are the grounds? So the grounds were also given in this case. So the first ground is, it was passed without application of mind. So if the court feels that the mercy petition was passed or rejected without any application of mind, then definitely it could have been intervened by the way of judicial review. Then the second ground is, it is malified in nature. And the third ground is, it was passed on extraneous or wholly irrelevant considerations. Then the fourth ground is, relevant materials were kept out of consideration. Then the fifth ground is, it suffers from arbitrariness. So as per this decision of Supreme Court in 2006, the dismissal of mercy petitions could be challenged on these following grounds. But as I was explaining this before, section 437 clause 7 of the proposed BNSS is in direct conflict with the judgment of the Supreme Court in this case. And it lays down that the President's decision on the mercy plea shall be final. The word used here is shall, that is, it is mandatory. And any question as to the arriving of the decision by the President shall not be inquired into any court. So they are using the word shall here. Shall itself denotes that the provision is mandatory in nature. So that is why it is in direct conflict with the decision of the Supreme Court. Then the Supreme Court in the important case of Shatrun Chauhan versus Union of India, which is regarded as a landmark case on humanitarian aspects of the death sentence, observed that death sentence is a kind of torture, mentally also and for the family also. So if there are possibilities that Article 21 of the convict can be protected, though he is on the death row, the Supreme Court will make every effort to protect the Article 21 of the convict, as well as every citizen of India has a right to life and right to live. So they considered this on very humanitarian grounds, that yes, they also have a right to live, and if the sentence can be commuted or condoned, then they will definitely protect Article 21 of the convicts as well. So in Shatrun Chauhan and another versus Union of India, a 3-judge bench of the Supreme Court commuted the death sentences of 15 convicts in 2014. So I was explaining this only, that their death sentence was commuted because the Supreme Court took into consideration Article 21 of our Indian Constitution and made it available to the convicts as well. So some other guidelines were also laid down in the this case for protection of the convicts who are facing the death sentence. And one such guideline was a 14-day, mandatory 14-day period when they got to know about the dismissal of their mercy petition and its execution. So a time period of 14 days was given by the Supreme Court in this case, and this 14 days period could be used by the convict to mentally prepare himself for the execution of the death sentence and get rid of his earthly duties. So to mentally prepare the convict and to help him facilitate his earthly responsibilities before this sentence could be executed, the Supreme Court gave this time in this case. But if you talk about the newly introduced provisions of the BNSS, this time period of 2 weeks or 14 days has not been mentioned in the provisions. So they have also not mentioned the provision of a 14-day time gap between the dismissal of the mercy petition and its execution. So the proposed provisions of the BNSS are also in conflict with the Supreme Court important judgment, landmark judgment in the case of Shatrun Chauhan versus Union of India. Then in this case itself, that the court held that no inordinate delay in disposal of mercy petitions. So I was talking about that the time limit. The president has no time limit. He can sit on the mercy petition, and this is very detrimental to the mental health of the accused. So in this case, the Supreme Court said that if there is an inordinate delay in deciding the mercy petitions, then by invoking Article 32 of our Indian Constitution, which is also known as the heart and soul of our Indian Constitution, the Supreme Court could commute the death sentence into life imprisonment. Death sentence into LI. So the Supreme Court was very against about the inordinate delays in deciding the mercy petitions, and the court in this case held that we will then invoke Article 32 and will commute, because we are trying to protect Article 21 of the convict. That is why we could interfere when there is an inordinate delay. But if we see the newly introduced provisions of the BNSS, there has been no time limit to decide. Though there is a time limit for the center to give its recommendations to the president, but there is no time limit for the president to decide the mercy petition. And in this case, only the court suggested that the president should decide the mercy petition within 3 months. But then there is no mention of such time limit in the newly introduced provisions of the Bhartiya Nyay Suraksha Sanhita. So somewhere or the other, they are coming in direct conflict with the Supreme Court judgments. Now let us see past cases of multiplicity of mercy petitions. So what happened was, there was an issue of multiple mercy petitions by different convicts. For example, in 1991, Yaqub Memon, who was accused by in the Mumbai bombings and was sentenced in 2015, and he presented various multiple mercy petitions. And we often hear in news also that the Supreme Court is sitting in midnight before the execution of the sentence to decide whether the death sentence should be executed or not. The Nirbhaya case being the recent example, in which different convicts approach or knock the door of the courts at different times. To solve this problem, the proposed BNSS makes the jail superintendent responsible. It says that by introducing a provision that the jail superintendent will decide and will ask every convict that whether they want to file the mercy petition, and with the time period is 60 days. So in cases with multiple convicts, the superintendent ensures all convicts file a mercy petition within 60 days. So this provisions tries to solve the problem of multiple mercy petitions, and it also lays down that the president will decide the mercy petitions of all the convicts in a particular case collectively. He will not entertain different mercy petitions by different convicts. Then a 60 days time has as I was discussing this before also, a 60 days time has been prescribed for the central government to send its recommendations to the President of India regarding the mercy petition of the convict. But however, no time limit has been prescribed for the President to act on the mercy petition. So this was all about the changes and the new changes introduced in the Bhartiya Nyay Suraksha Sanhita. So with this, we come to a conclusion of today's discussion. We have seen and analyzed the law on mercy petitions. We have seen what is a mercy petition and why is it so important. And we have also seen the Indian constitutional provisions regarding mercy petitions and the newly introduced provisions in the Bhartiya Nyay Suraksha Sanhita. The best part about BNS is it is still in a bill form. It has not been passed and it is not a law. So let us see what happens when it finally becomes a law. So now let us discuss a practice question for your prelims examination. So the question is, consider the following statements regarding mercy petitions in India. Your statement number 1 is, a convict can present a mercy petition to the President of India under Article 72 of the Constitution of India. Your statement number 2 is, the decision of the President dismissing the mercy petition cannot be questioned in any court of law. Then your statement number 3 is, the mercy petition cannot be claimed by the convict as his/her right and it is at the discretion of the authority to which it is made. Which of the following statements given above are correct? Your options are, option A is 1 only, option 2 is 1 and 2 only, option C is 2 and 3 only, and option D is 1, 2 and 3. Kindly drop your answer in the comment box below. Now let us see a practice question for your mains examination. So the question is, explain the pardoning power of the President under Article 72 of the Indian Constitution. In introduction, you will explain Article 72 of the Indian Constitution. You will mention about the power to pardon, reprieve, remit or commute the sentence. You will explain all of these terms. You will say what the Supreme Court judgments have held in this regard, and you will also compare it to the power of governor in under Article 161 of the Indian Constitution. And you will also write about how President mercy petition or the power of the President is a very unique right given to the convict of who are on the row of death sentences or life imprisonment. So with this, you can conclude your mains answer. I hope this session was insightful for you. If you have any feedback regarding this session, kindly drop it in the comment box below. If you found today's discussion helpful, kindly like the video and subscribe to our channel for more such updates. Thank you.